Subcommittee on Oversight and Investigations is meeting today to hear testimony on BLM's Draft Resource Management Planning Rule. This draft rule is part of BLM's Planning 2.0 initiative, and it completely upends the current process by which the agency prepares and amends resource management plans that govern public lands. Getting the planning process right is crucial because the effects of resource management plans on communities throughout the West cannot be overstated. In some counties where the federal government owns a majority of the land, the decisions that BLM makes have an outsized impact. Families and local economies can and do suffer as a direct result of BLM's unaccountable Washington, D.C. bureaucracy. That's why Congress specifically prioritized the input of those who are most affected by BLM's resource management plans. The Federal Land Policy and Management Act made clear that BLM must coordinate with local governments on management plans. BLM's Planning 2.0 effort and this draft rule appears to ignore the law and undermines the communities that neighbor BLM land. From refusing to further extend the comment period to cutting local communities out of the resource management planning process, BLM has perfectly illustrated why so many people feel that the federal government's not a good neighbor. BLM heard from numerous local governments, interested organizations, and Congress that significantly more time was needed to comment on the draft rule. BLM extended the comment period for only 30 days, effectively saying, no thanks, we don't need to hear from all of you. That probably should not have been a surprise, since in many ways the draft rule seems to be designed to increase Washington's influence while minimizing BLM's responsibility to work with the states and local government and affected people. We're here today to remind BLM of its obligation to cooperate with its neighbors, to provide an opportunity for those who are most invested in an effective and efficient planning process to share their expertise. They're not in existence to repeatedly infuriate local landowners until they are provoked to violence and resulting in the death of a landowner, as we have seen. Many people have acknowledged that the planning process could be improved, but BLM's draft rule, as it is currently written, is not a workable solution. At a minimum, BLM needs to reopen the comment period to allow for full and substantive input on the complex rule. Ideally, BLM should go back to the drawing board and partner closely with the state and local governments to make sure the resource management planning process works for everyone, not just agency officials. In closing, I want to say thank you to our witnesses. Most of them have traveled a great distance, and obviously you don't come for the money because you don't get paid. This is all because you care about our country and our freedoms, and so we much appreciate your willingness to come share your thoughts and your observations with us, and we look forward to your testimony. Of course, we know that there can be significant changes that occur between the original draft of a resource management plan and the finalization of the research management plan. So it is critical that the BLM hears from everyone who is a stakeholder, and that especially includes governors that represent the whole state, even though their voice may be more in line with the majority, and commissioners, county officials, and certainly the landowners themselves. And that's why I'm pleased with the representation we have here. Longer comment periods would seem to make that more likely. And let's see, there was a hearing recently before the Senate Energy and Natural Resources Committee, and Director Cornsey suggested that it makes sense to retain longer comment periods, although it did take some prodding from Senator Warren. Mr. Lyons, do you disagree with Director Cornsey? Do you think we should have the longer comment periods, go back to those, or do you still insist that we should have shorter comment times?
No, Mr. Chairman, Director Cornsey and I have had a conversation about that, and that's certainly something we're willing to revisit. I should explain that in an attempt to limit the amount of time spent on planning in providing additional information or opportunities for input up front, think an effort was made to cut back on some of those later comment periods. I think we need to rethink that, as you suggest.
Well, thank you. I'm glad to hear. We're very glad to hear you say that. Mr. Augsbury, have you heard any stories from Western governors where specific instances where they were not allowed the voices that they felt they should have in policies that affected the people in their states?
Chairman Gohmert, members of the committee, I would appreciate the opportunity to provide a more thoughtful answer for the record. In the meantime, I would suggest that in the course of consistency reviews that were issued with respect to the sage grouse, RMPs, that there was considerable concern expressed by a number of governors that there was not enough attention paid to those consistency reviews.
Well, I don't know. We've got representation from the various aspects, stakeholders. What I've heard in my district in dealing with federal land issues is that sometimes a plan is being proposed and they don't see word of it. They don't feel like they get proper notice, and then all of a sudden their time's run out. Mr. Fontaine, are you aware of any situations like that where commissioners didn't feel like they had adequate time to respond?
Mr. Chairman, thank you for the question. I think that is the case for many of our counties. We have a number of small rural counties that, quite frankly, don't have staff. I think we have 8 or 9 counties in our state that don't even have a county manager. And so even if the BLM, for example, might submit an email indicating that there might be some plan that's being considered, including this planning initiative, it's one of many emails that they may get and may not have the opportunity to review that and give some thoughtful comment on that plan. We think that the better course would be for really the BLM to reach out to those counties and to our association as well.
Well, you made a great point. My counties where federal land is located normally have less assets to utilize. Like you're saying, you can't tax the federal land. It's not being used now where it should be used to produce timber. That was the original idea. It's a renewable resource. These aren't sequoias, pine trees. And they're struggling. The schools struggle, and they don't have the ability to respond. And I appreciate that point being made. And my time's running out, but I just would ask all of you, and including Ms. Clark, you've got special experience from all sides, but if you have specific instances that you can find where the rules have worked a hardship, then let us know those. Please send us those in the days ahead. I'm struggling here. Given the significant impact that this rule is going to have on the 12 western states, where the federal government, the BLM, owns so much of that land, and given the disproportionate impact that this Rule 2.0 is going to have on these 12 states, why did the BLM choose not to travel to those states and have field hearings and hear directly from the people most effective? And as Mr. Fontaine points out, I mean, some of these counties, because there's so much federal land in their county, they don't have the resources to come to Washington to lobby like other special interest groups do. Why was there not even a trip to the sites that are going to be so materially affected before this was put out as the rule? Mr. Lyons.
Yes, Mr. Chairman. I would say this. We have done outreach, as I said before. We have sought input. We've gotten over 6,000 comments on the rule, which I'm glad to provide for the record if you like. And Our intent is not to have people come to Washington. Our goal is to engage with people on the ground. That's the way the plans would be implemented. It's no different than the way things occur now with regard to cooperator status.
what
I
we're
would
worried
emphasize that we have worked through our RACs, and again, I can provide this information for the record, our resource advisory committees, who are locally representative, to secure additional input and feedback on the rules as well. So we're trying to engage at that level, and to engage as well on a regional level to secure information that will help us improve the rule. This conversation is interesting and helpful in helping us to decide how we're going to finalize the rule. As I indicated to the chairman, we're not done yet, and we certainly appreciate the feedback.
Well, what about extending the rule or extending the comment period for the rule itself?
Well,
Since you and Director Cornsey you've talked and you think it'd be a good idea to extend it within the rule, how about extending the comment period for the rule?
Frankly, Mr. Chairman, I think this conversation to be had with the director, but I would suggest that we've done our utmost over the period of time that we've been working on this rule to try to secure additional input. And now it's time to finalize a rule based on all the input we received, and then apply it.
Well,
and we can.
You're hearing from people who represent areas in the West. You're hearing from others saying, "Give us more time." We invited Director Cornsey, and they sent you to answer for him. So that's why you are being asked the question. You're answering for the director. You're the one they sent. So I would appreciate if you wouldn't pawn it off on the director when he sent you to answer. And it sounds like you're saying, we're not extending the comment period. We've got our little bevy of folks around here in Washington. We haven't been to those areas. We're going to materially impact them, and we don't care. We got our plan, and we may extend the comment period within the plan for other rules, but the big killer plan, we're going to leave it right where it is. We're satisfied with our little crew right here in Washington. That is the impression you're given. And then when you throw it back to Director Cornsey when he sent you to testify on his behalf, it gives me a lot of concern. Mr. Ogsbury, don't the Western governors, aren't they pleading for more comment period before 2.0 is put in as a finalized rule?
Chairman Gohmert, members of the committee, the Western governors are pleading for BLM to take a step back and take their concerns into account.
And let me just say this, since my time is running out. It looks like we're heading to a CR or an omnibus, and the Republican leaders come to people like me and they say, look, we need you and we need other conservatives like you. What will it take? And I tell you what, we're about to get to the point where it's going to take gutting BLM's leadership until we get people who will be responsive to the people that they're gutting. That may be what I need to support the CR or omnibus if we don't get more responsiveness out of BLM.